seminar. I'm Cheryl Lother. I'm the Director of the Human Rights Centre at Queen's, for those of you who don't know me. What we're doing this afternoon, as we can't in person at the moment, is we're trying to take as many of our activities online as possible. And Fionnuala and I came up with the idea of hosting a seminar series on some of the most pressing and some of the most topical human rights issues in light of the current coronavirus pandemic. So we have this afternoon seminar on emergency powers, and then we have a second seminar next week on coronavirus and managing the dead, and another seminar the week after on the impact of coronavirus, lockdown, and gender and domestic issues. So please feel free to join us for the seminar series. If there's any of them that you can't attend, we are recording these seminars and we'll be putting them on the human rights section of the School of Law's website. So you will be able to catch up with anything you've missed afterwards. Before we start today, I just have a couple of different housekeeping matters to outline. So can everyone who is not one of our participants this afternoon, can you please keep your microphones off and your video off? And what I would suggest that we do is, we only have an hour this afternoon. So what I suggest that we do is we use the chat function, which I think most people are familiar with. If not, it's very easy to use. If we use the chat function for posting any questions, and we'll have about 15 minutes or so for Q&A at the end of the seminar, and I'll pick up on those questions and pose them to our participants at the end. So to crack on with today's seminar, as you know, today's seminar is on COVID-19 or coronavirus and emergency powers, emergency provisions. And we'd have two absolute expert speakers who have kindly given up their time to join us this afternoon. Our first speaker is Professor Fionnuala Ni Aolain, who is Professor of Law both at Queen's and at the University of Minnesota Law School. And she is also the UN Special Rapporteur for the protection and promotion of human rights while countering terrorism. Our second speaker then is Herrick, who is the Executive Director of the Irish Council on Civil Liberties. So, as I'm sure you'll agree, we couldn't have two better placed speakers this afternoon to contribute and to kick off our first edition of the seminar series. So I'm going to hand over to Fionnuala to start us off. And Fionnuala's got about 20 minutes to speak, and then we'll hand over to Liam. And as I said, if you're interested or you've got any comments or any questions, please use the chat function and we'll pick up on them at the end. So Fionnuala, over to you.
Great, thank you. Good morning. Well, it's good morning. I find myself on the wrong side of the Atlantic in the middle of this COVID-19 crisis. So I'm really pleased to start the conversation today. I'm going to do some things which will be very familiar to many on the chat, because emergency powers are not new to many of us who live on the island of Ireland. Emergency powers have a long and distinguished history on the island, but it is interesting that some of our conversations over many decades, I think, are highly relevant to the global conversation that's being had about the use of exceptional powers in the context of COVID-19. Let me start by just briefly outlining, for those who are not familiar with the concept and practice of emergencies, a little bit of the relevant law, and then I'm going to focus on the global challenges that my Office of Special Rapporteur is currently experiencing and some of the issues we are grappling with in relation to government practice. So the idea of an emergency is the use of an exceptional power. It is the idea that the state, when any state is experiencing an exceptional challenge, that it has the right essentially to limit rights or to limit the exercise of rights under law. That idea of the right to limit rights is in fact built into and part and parcel of our international human rights system. We find that prerogative or right to limit rights in derogation provisions of human rights treaties, which allows states to do a number of things. And the first thing they can do is, of course, notify other states that they are planning to limit rights. They can proclaim that publicly. And then they can set out to under their various treaty obligations, the ways in which various rights are being limited. We are seeing right now, as many of you will be aware, as we are hunkered down in our homes, limitations on a range of rights, including most obviously freedom of movement. But in a number of countries, we're seeing limits on freedom of expression, limits on trial, limits on due process rights, limits on the expression of freedom of religion and other rights. So there's a range of rights implicated by this. It is, of course, an obvious point that the fundamental right, the right to life, is in part the raison d'etre of those limitations. So that sense that, in fact, there's a balance of rights in play here is one that's also really obvious and pertinent. So the right to limit rights isn't unrestricted, and states do not have a carte blanche. When states exercise the power of the right of derogation, they are constrained in a number of ways. So the first of those constraints is one that many on the call will be familiar with, which is that it has to be necessary. There has to be a necessity to limit rights. Generally, we use other measures like proportionality, non-discrimination, and legality as a way of testing and understanding whether a state is operating within its international legal obligations when it limits rights. So let me just say a little bit about the global experience, and maybe one that we're also familiar with on the island in the context of this call. Rights limitation or the use of emergency powers generally isn't something that is easy to undo. So one of the takeaway lessons that many of us are familiar with is that when a state limits rights in general, or when a state aggregates its power in the use of emergency powers, it's actually very difficult to undo that disaggregation or that aggregation. States generally hold on to the powers that they have accumulated. And so undoing exceptional powers, undoing emergency law is extremely difficult. The second general thing that many of us know is that emergency powers, which are often taken for a brief or told that they're being taken for brief or short periods of time, those often tend to perpetuate, meaning that it's very difficult to enforce the temporality requirement that the limitations on rights only be undertaken for limited periods and for exceptional reasons. And the third thing I think what we would know about the challenge of regulating emergency rights is that oversight is extremely difficult, and ensuring that states, in fact, exercise these limitations on rights in a restrained way is exceptionally challenging. So the idea of derogation assumes that states are in fact going to tell us that they are in fact limiting the exercise of rights or taking exceptional measures. And one of the key trends that my mandate has seen over the last 2 decades in particular has been a lack of notification by states that they are in fact using exceptional powers. The report that the mandate issued to the Human Rights Council in the spring of 2018 focused specifically on derogation, and it was focused primarily on derogation in the context of counterterrorism, but more broadly assessed global trends on exceptionality. And I think one of the key things that I was identifying was the lack of consistent notification, proclamation, or simply statement of fact that there was an emergency in many countries. And one of the reasons for that, as I think all of us might be aware, is that emergency law has the tendency to come into domestic law or regular law in a way that's not obvious. And that's also happening with the pandemic. So instead of seeing a piece of legislation entitled emergency powers related to the COVID crisis, we're seeing things called health bills or sanitation bills, where it's not obvious that they are in fact a piece of exceptional legislation. So even finding what is exceptional in the terrain of powers being used by the state can often be difficult. And so that's one very obvious trend that we've seen generally since the events of 9/11, but I think it's also pertinent to the COVID crisis, that states are increasingly not proclaiming or naming that they're in an exceptional situation. What that also demonstrates is that the use of de facto emergencies is on the rise. And so that makes it extremely difficult to do any kind of international oversight, but also even for domestic organizations, for NGOs, for civil society, actually ferreting out what is your exceptional practice can be difficult. Finally, I think it's worth noting, and a number of the states that the mandate is dealing with have pre-existing emergencies. So I think of countries like Sri Lanka, like Egypt, and in most states, there are existing emergencies, and those emergencies, in fact, form the backdrop to the proclamation or the use of new powers. In some cases, for example, in Sri Lanka, there's been no need to proclaim a new emergency, and the government is relying primarily on its existing powers. It doesn't need COVID-19 special powers because the scale of emergency capacity in the state is really deep. But the use of emergency powers that were designed, for example, in response to a terrorist attack, are not quite the same as the kinds of precise and tailored emergencies that international law would assume or expect to be implemented in a situation of health emergency. So I think we're seeing a number of repurposings of international or existing legislation in a number of domestic settings around COVID-19 that are extremely worrying. One of my concerns as Special Rapporteur has been that while we're very clearly dealing with a pandemic, globally, I think that my office is aware that we are seeing what I've been calling an epidemic of emergency powers in many parts of the world, both formally proclaimed, but more often than not, we're seeing either de facto emergencies or these complex emergencies where emergency powers around COVID are being layered into existing emergency structures. The range of those powers in many cases, some are appropriate, but the vast majority that the mandate is tracking seem to take the opportunity of COVID-19 to expand and extend the range of powers available to the state in ways that are at least facially inconsistent with the state's international law obligations. And that is deeply concerning. I think the other thing that we are seeing is the use of powers in many national settings to essentially extend practices of repression or practices of misuse or misuse of the rule of law by states by virtue of the opportunity of COVID-19. And that again is deeply concerning, not least because states are otherwise occupied. And so the normal kinds of at least oversight or bilateral criticism or the opportunity even for the Human Rights Council to meet in person or for the Security Council or the General Assembly to meet are absent. Many of those bodies are not functioning in the same way at all as they used to. And so states who wish to abuse emergency powers are in the position where the gaze of other states is taken away. Let me finally just speak to some of the ways in which my office has been tracking, the Special Rapporteur's office has been tracking the use of emergency powers at this time. In the immediate aftermath of the WHO declaring the pandemic, I was in Geneva for the annual meeting of the Council in March, and I decided with my legal team that we would try to globally track what we were seeing, partly because it's very difficult to do oversight if you're not able to tell what states are up to. So we've created a tracker with two NGOs, ECNL and ICNL, two civil society non-governmental organizations who have helped me essentially create a tracker on state responses to the COVID-19 crisis. And that tracker we'll put up in the chat so folks can follow through and see. And it's really, at this point, trying to simply put up everything we know around primary legislation being used by states in response to the crisis. Now, it has the obvious limitation that it's only tracking formal emergencies. And so we need, I think, I've talked about needing a SWAT team of lawyers to be able to identify the other range of practices that states are using, particularly around de facto emergencies where there's no proclamation, or to be more fully aware of how complex emergencies are being managed. The other thing I would say is that the Office of the High Commission has created a website where there are a whole range of tools being developed to help oversee state practice in this area, particularly tools that are aimed at non-governmental organizations and civil society. And I think the other thing we've seen just this week is that the Human Rights Committee issued short guidance on April 24th, just a 2-page guidance from the committee on the committee's expectations from states on the requirements to notify under the ICCPR. Finally, let me close out by saying that in addition to, I think, the challenges of overreach, one of the main concerns that at least I have at this moment is that we're going to see a whole range of new challenges, given the extent and the potential length of emergency practice by states around COVID. Two particular things I'd flag for the group listening today. One is the repurposing of tools, particularly technological tools that have been used in the counterterrorism arena into COVID-19 responses. And there in particular, the use of surveillance tools is one that my office follows really closely, but we're really profoundly concerned about the kind of repurposing of surveillance and in particular biometric data collection tools. There are a few good privacy regimes in place that are fully, I think, up to date with the kinds of technologies that are available to states at this time. There's been enormous technology transfer from some states, in particular from China, to a number of states on this kind of surveillance technology, which has been in part limited, or at least somewhat limited. And I think, very concerned that this is the perfect opportunity to make those tools widely available and used with all of the attendant problems around privacy and other rights. And finally, I think it would be for all of us, we might wake up, all of us, I think, are hoping to wake up the day after the pandemic and feel that the world is the same. But the world as we know may not be the same at all in many dimensions, not least because of the scale and the scope of harm that has been caused by the crisis, but also as we are facing this epidemic of emergency powers and exceptional practices by states, that in fact the societies we return to may be less open, they may be less rule of law compliant, the executives may be empowered in ways that we haven't anticipated, policing practices may have fundamentally changed in the sense of the power and the scope of intrusion available to police forces in many parts of the world. And so we may be looking at a world that is less free, less open, where authoritarians are empowered in new ways. And I think that's something we all have to caution and guard against. And so the importance of having the conversation about overuse, I think, has never been more important than now. So let me stop and hand over to Liam.
Thanks very much, Fionnuala. It's for a fascinating overview and some very timely, but also some very problematic questions there posed for us at the end. If I could hand over to Liam now, we can take a closer look at the impact of emergency provisions in the Irish context.
Thanks very much, Cheryl, and hi everybody. Thanks for joining us today. I'm the director of the Irish Council for Civil Liberties, based in the Republic, and we are an independent non-governmental organisation that's been in existence for over 40 years. Our perspective on this from the outset has been to try to ensure that human rights were taken into account in all of the key policy and legislative decisions that have been taken since the beginning of this crisis in March, and also with an eye to the longer term, to try to ensure that every step taken now will ease the speed with which we can return to the current status quo of constitutional and human rights afterwards. Just a few overall observations before maybe I run through what's happened here. The first thing, I suppose, picking up on something Fionnuala has said, this is not an emergency in the Irish constitutional sense. The Irish Constitution only provides for in an emergency during a time of war or armed rebellion. And the government hasn't asserted that this is an emergency. It hasn't derogated from its international obligations, even though the substance of much of what has happened has had all the hallmarks of an emergency. So they are working within the existing constitutional framework. There hasn't really been many challenges yet to the constitutionality of what's happened here, with the exception of one case taken by individuals who we generally don't tend to refer to by name, but would be associated with far-right activism and don't seem to have much prospect of success. The government strategy has been built around three elements. The first is a centralized public health system of advice, rotating around a national public health emergency team, which gives daily briefings, usually voiced through the chief medical officer. Then there's a legislative basis under two pieces of legislation that have been enacted by the Oireachtas, which I'll come to, which provide for some extraordinary powers in and of themselves, but primarily give the Minister for Health the statutory power to make regulations affecting movement and public events. And then the third element of it is those regulations themselves. And we have had two sets of regulations which directly impinge on broad human rights concerns, and a number of other regulations to do with matters about welfare, employment, administration, registration of doctors and medical workers, and so on. So if I might just go through, I suppose, the sequence. The government flagged on the weekend before St. Patrick's Day, the week between the 9th and the 13th of March, that it intended to introduce emergency legislation. Very little was given away in terms of what the content was, but a drafting process clearly began. As an aside, the first steps taken by the government here, below the level of legislation, were in the social welfare area. They passed through some emergency administrative measures to create emergency COVID payments. And one of the benefits, if you like, early on, was the government dispensed with the requirement for the public service card, a controversial national identity card system, as an essential requirement to access welfare, because they couldn't process public service card applications during that period of time. That's something maybe I can come back to in the questions and answers. But we've used this actually with UN Special Rapporteur Philip Alston as a demonstration that the public service card is an obstacle to welfare as opposed to a tool. But the key measure from a statutory perspective was what became known as the Health, Preservation and Protection and Other Emergency Measures in the Public Interest, lovely mouthful, Bill 2020. The government had flagged it. ICCL came out very early on and basically articulated what the framework should be for this legislation, articulating principles of lawfulness, proportionality and necessity, even before the bill was published. And then when it was published, we came out and immediately articulated a framework and particularly focused on the question of temporality and the need for a defined period of the emergency, the de facto emergency. This became pretty crucial early on because in the first draft of the bill, which the public only saw on the 18th, the day after it was announced, and this is a kind of pattern we've had throughout this process, the government originally proposed that the period of emergency would be short, only for a number of weeks, but that the Minister for Health would have the discretion to extend that emergency period without going back to the Oireachtas. And given our historical experience here in Ireland about the duration of emergencies, we felt it was absolutely essential that it had to be Oireachtas control. So when we submitted suggested amendments and analysis of the bill to all members of the Oireachtas on the 18th of March, and obviously everything happened in a short space of time, ultimately that recommendation was taken up, and the government did accept amendments that the Oireachtas should have the ultimate control on the period of the emergency. Unfortunately, the trade-off for that was that the period is until November. So where we have now is that this piece of legislation, the provisions that relate to human rights and restrictions on civil liberties, the power of the minister to make regulations lasts until the 9th of November. The substantive elements of the bill, it created self-standing powers allowing a medical officer to detain somebody, and unfortunately recommendations that we made about safeguards, about thresholds and oversight were not accepted. We have very little information about how many times this power has been used. We understand it's quite small, it's in single digits. And then the other main provisions related to the minister having power to regulate public events and public movement. So that was on the 19th and 20th of March. It was rushed through the Oireachtas. Some amendments were accepted in Doyle, not very many, and no amendments were accepted in the Shannon. The sunset clause was accepted, which we see as a big victory for civil liberties and human rights. So the regulations then, you might have thought would follow on quite quickly. However, that wasn't the case. What happened was that even though the regulations drafting began immediately, there was a period of over 2 weeks where the legislation was there. And then on the 27th of March, the National Public Health Emergency Team issued guidelines which talked about essential movement, essential work, reasonable excuses, giving directions to the people as to what they could do and all of the semi-lockdown features that we've become familiar with. But between the 27th of March and the 7th of April, there were no regulations introduced, and the Guards mounted a large-scale operation of advice and guidance to the public without any underpinning legal powers. On the 7th of April, that changed. The reasons why it changed are not quite clear, because we had the Taoiseach earlier on the 7th talking about the success of the consent-based approach, and that evening the Minister for Health signing regulations to create enforceable powers to the Guards. ICCL made observations on the regulations, but ultimately few of them were accepted. There are powers now of arrest, detention, imprisonment and fines underpinning them. And one of the reasons why it seems to have moved from consent to enforcement was that the Guards had indicated that they wanted to have a large-scale operation over the Easter bank holiday weekend, and they felt they needed to have legal certainty around that. So there was, the regulations, interestingly, were only introduced for a 5-day period, which matched the public health period from 27th of March to 11th of April. So the regulations were introduced on the 7th, but only to last until the 11th. We can understand, I suppose, there was a rush during that period of time, but then the public health advice was extended on the 10th of April until the 5th of May, and the regulations just rolled over too. There was no reflection on the experience of enforcement over the first period, no reflection on disproportionate impact on particular groups, no reflection on whether it might be possible to reduce the enforcement in certain areas. And we see that as a missed opportunity and I think a mistake. So we're now in a period of national public health advice from the 10th of April to the 5th of May, and corresponding and parallel set of regulations creating powers of enforcement, which also lasts until the 5th of May. I suppose a key concern for ICCL has been about the policing element of this. The Garda Commissioner has at all points emphasised that consent is the starting point. They talk about an approach to policing based on engagement, encouragement, explaining before reaching enforcement. The Taoiseach and the Garda Commissioner have said that the powers are intended to be used very sparingly. notwithstanding the fact that there are powers of enforcement. The Garda Commissioner is on a weekly basis announcing statistics about the number of arrests and charges, and they do indeed seem to be relatively low under the regulations. And there was a figure given on Tuesday of this week of, the last Tuesday, of 34 arrests under the regulation in that week period. At the same time, we are receiving a significant number of contacts from members of the public expressing some concern about the nature of the checkpoints, behaviour by guards at checkpoints, the intensity of checkpoints and stop and search operations in some communities, particular strong concern about the use of armed police in what is an unarmed police service at checkpoints, and also then the interpretation by some members of the guards of what is a reasonable excuse, whether people can go to particular shops, whether people can go to particular types of work and so on. And some people alleging an invasive approach by some guards. A key question here, of course, is the guards asking people for identity or other documents, which is not normal in the conduct of Irish policing. The use of the public order unit to support guard operations, and a particular concern around how the guards have approached demonstrations and protests and the consistency with which they've addressed those. We've this weekend then had reports that one local authority has been collecting drone footage about people on holidays and passing that on to the guards. So all of these concerns we are sending on to the guards and to the policing authority, and the policing authority will have a hearing tomorrow where many of these concerns will be voiced. Our concern is about a long-term change to the nature of Irish policing, and we're in constant contact on a daily basis with the guards, the policing authority and the Department of Justice on this. One other measure which is coming is surveillance. The HSE, Health Service Executive, is developing an app for contact tracing, symptom monitoring, and we have many concerns around this. This is a main focus for us this week. This week is crucial. So what we are saying in the Irish Council for Civil Liberties, along with a coalition of other civil society actors, is that during this week, when the Taoiseach says that the government is reviewing what it's going to do next in terms of restrictions and regulations, that there should be a human rights impact assessment on how the current regulations are impacting particular communities. We have no indication that's going to happen. We know that the government will be making decisions over the course of this week, and it's not clear whether they will ease some of the restrictions, whether they will amend them, whether they will allow certain discretion for certain communities. We know that travellers, Roma, asylum seekers, homeless people, people suffering with mental ill health, people with families with children with disabilities, and victims of domestic violence are all groups that are disproportionately impacted at the moment. The Human Rights and Equality Commission has also been making similar points. So this is a crucial couple of days. We've asked our members and supporters to contact TDs to make this message to the government. Just in conclusion, I would say that overall, there has been good centralised communications from government, and there's generally good compliance and public confidence in what is happening here. But there is some fraying of the translation of the public health advice into legislation and policing. There is some lack of clarity about who's making decisions. There are growing political concerns about a lack of transparency about how the National Public Health Emergency Team operates. This is coupled with a reduced operation of Parliament and parliamentary oversight for obvious logistical reasons, and a lack of normal operation of the courts. So I think we will see more focus and a more assertive political scrutiny of what's happening. And certainly I think the message we're giving to government that this week is crucial. There is a high level of public confidence and trust, but if they want to maintain that, the counterpoint is transparency and accountability and a demonstration of taking into account human rights. I think it's in the balance. I think overall The approach of the guards has been moderate, and we would be open in saying that. But the longer it goes on, the nature of the policing operation changes. So I think in the next couple of days, we'll see some crucial stages here. And the guards have announced an escalated police operation over the coming weekend, particularly monitoring people that might travel around the country for holiday purposes. So that's where we are at the moment. I think we're obviously internationally comparing quite well, and we're looking at what's happening and succeeding in other jurisdictions and failing, and we're trying to use that knowledge to inform what we're recommending to government here. So I think I'll leave it for there and take up any points in questions.
Super, thank you very much, Liam. It's a very thought-provoking discussion there for us this afternoon. I'm not yet seeing any questions in the chat bar, but if anyone would like to come in, please do. In the interim, I will take advantage of my role as a moderator this afternoon. I have a couple of questions for both of you. And I was thinking in particular, Fionnuala, but also Liam, about this idea of kind of role creep of counterterrorism tools. And I wondered if you could both perhaps comment on the potential impact of that, particularly in relation to Northern Ireland and the provisions and the spirit of the Good Friday Agreement and the peace process.
Yeah, maybe Liam, I'll start generally, and I think there may also, I know there's a number on the call who know quite a bit about this too. I would just say generally that in a number of countries we're seeing repurposing. Perhaps the most obvious one that was, I think, most sort of largely covered outside of national boundaries was in Israel. There was a decision by the government to use surveillance tools that have largely been associated, applied not generally inside Israel, but applied in the occupied Palestinian territories. And that was taken, a proceeding was taken to the High Court of Justice, the Israeli Supreme Court, to challenge the sort of repurposing there. We've seen in Poland is another example. The Polish government has been thinking about, although they have not yet mandated, the national use of an app that requires, you can look, those of you online can look it up. It's an app that you would download and it would record your movements. Singapore and others have been also focused on using tools that have an origin point in counterterrorism space. So I think one of the really big challenges here is that individuals' level of fear is so high, and the known and the known knowns and the unknown at this point are so significant in terms of the health piece of this, that individuals are quite prepared to give away large amounts of personal private data about themselves, and are not, at least in many jurisdictions, voicing concern about what the consequences of either information being gathered about their movement, personal biometric data being shared with police forces and a range of other actors where the chain of is not well known or even necessarily secure. And people feel so there's a sense of a giveaway on those fundamental rights. And I think, fear making in a time of crisis, it's never a good time to ask someone what they're prepared to give away when they're afraid, because generally the answer is that they're prepared to give away quite a lot. And I think that's the real concern, that the consequences of that ease of use, what the access to that kind of personal data, whether it's location data or personal biometric data for people, it's deeply attractive to states. For obvious reasons. And once that genie is out of the bottle in a number of jurisdictions, that's really difficult. I think the other piece I would say is that in countries and in contexts such as Northern Ireland, where there has been a long-standing sort of a history of misuse of counter-terrorism measures and a long, deep and substantial need to monitor that. And unlike many other jurisdictions, there are robust monitoring, at least of counterterrorism measures in the UK. But I think the danger is that COVID kind of creates a normalization of those exceptional measures. And I think Liam hasn't spoken to the cross-border issues, but of course there are really clear cross-border challenges about monitoring, stopping individuals travelling, for example, to second homes in the Republic from Northern Ireland, individuals who have family members on both sides of the border, where there are issues not just of travel, but the right to life, the right to family life. So all of those, I think, are really complex challenges. And I think in many ways, we don't have a good roadmap, and governments, I think, are not erring to the side. We think about what is necessary, what is absolutely necessary here. I think that's really the key test, and very hard to hold governments to, actually. Liam may have something to say about that as well.
Thanks, Fionnuala. On the border point, it's come up in a couple of different contexts. The first one is a fairly widely shared concern, particularly on this side of the border, about the difficulties in the public health effort of differential approaches in the two jurisdictions. And a lot of focus politically here today on what are seen as disproportionately high rates of infection in some of the border counties. And this is being blamed, rightly or wrongly, on perceived differences in the approach on both jurisdictions. A second point that's come up for us has been some reports of interferences of travel across the border, where the travel would be for reasonable excuse, whether that might be for shopping or work or for family reasons. And the guards at the senior level have been sending out messages that this shouldn't happen, the border's not closed. On one hand, that's been a very strong message. On the other hand, you've had a very compelling narrative in the last couple of days about the fact that our powers of enforcement here don't extend to people travelling across the border for non-reasonable excuses, and the particular focus on people travelling to Donegal on their holidays from the north. So there is talk about changing the regulations there. Definitely the border stuff is difficult, and it is exposing all sorts of dissonances there. On the surveillance point, one thing that's been happening here is that all of the talk about proposals for the health service app have been coming from health. They have very little fingers from the Department of Justice on it. All indications are that Justice have not really been involved in any of the development side of it, which might be positive in terms of insulating health from counterterrorism. But what also is happening is there's no demonstration of taking into account data protection principles. There's no sharing or any transparency about what the purposes or functionality of the app are to be. And the HSE is not committing to sharing a data protection impact assessment before launching it. So there are all sorts of concerns there. Not that this is coming from counterterrorism, but rather that it's a solo run by health, which isn't taking into account some of the rights and privacy issues. And I think the big fear here is that it will be mandatory but not compulsory, that it'll be voluntary and it'll be consent-based in the initial phases, but then you may require to demonstrate your use of it if you're an essential worker or if you're trying to do certain things. And that's the creeping nature that we're very concerned about here. I'm not at all convinced the public are going to have a high take-up of it. I think there is a skepticism here of this type of technology, and we'll certainly be pushing this over the next couple of days unless there's more information forthcoming.
Super, thanks very much. You can probably see from the chat bar here that we've got a few questions coming in. So we'll start with Hannah Quirk's question. Hi, Hannah. And I think Hannah's question is really probably directed to Liam in the first instance. And that's about monitoring of court appearances and how that's being done in the South. As the case Hannah makes is in England, defence solicitors aren't going to police stations. The press are having some problems in respect to getting access to court appearances, and sentences seem to be disproportionately high. And I wonder if you could maybe comment on that in the Irish context.
We have only partial information on this. Certainly, we've been observing the fact that the guards have been opposing bail for people coming before the courts on COVID-related infringements, which is regrettable. particularly when the prison service has been doing a very good job of reducing the population. There's not that much information about sentencing yet. The number of cases has been low, and in fairness, it is a success that the number of charges seems to be low, at least so far. We are in contact with the Bar Council, and there is concern here, whereas the court service are trying to facilitate remote hearings and get the courts operational again. There is a concern that some of the move towards remote hearing and video evidence might actually serve a different agenda about costs saving in the longer term. I know this is a concern in England as well. So the Bar Council has set up a remote hearing subcommittee and is looking at this from the perspective of trying to facilitate access to justice, but also trying to preserve rights of equal access in the longer term. So that's all we can really probably say on that at this stage. The courts are operating on a reduced scale at present, and the courts of criminal justice are operating. We haven't had reports that people are being denied access to justice, but it's those kind of long-term concerns that we're hearing.
I would just add to it. So one of the challenges we've seen in a number of countries globally is who's designated this category of who's an essential worker, and including lawyers and judges in that has been one of the mandate's priorities or advice to governments that courts should remain, that's an essential piece of keeping the rule of law operative. We've had a couple of countries where there's been litigation on the non-inclusion of lawyers and judges as essential workers, so that would seem to be really key. I will say that the other piece of this is ensuring that lawyers and judges have meaningful access, and that goes to Liam's point about the extent to which the measures taken, particularly if they're going to be taken over the long time, what the optimization of access will be, as opposed to so ceilings, not floors. And as this starts to normalize, then I think that's going to be the critical question in terms of ensuring that there's an optimization of access to justice, particularly in the capacity to challenge measures that are being taken by the state that are highly intrusive.
Yeah, and just to say, all lawyers are regarded as essential workers here. There's no distinctions between different areas of practice or different functions. Everybody involved in the delivery of legal services is deemed to be an essential worker under the regs.
Helpful if I turn that on. Okay, thank you. We have a question to both of you there from Claire McCann, which I think you could probably both see. And Claire has asked if you have any observations in respect to the operation of emergency powers beyond policing. So, for example, in respect to healthcare and the rights of people who are in the social care system who are particularly impacted by coronavirus. And she's wondering whether governments have done enough to protect the Article 2 rights of people who are in social care, and what guidance can human rights offer, for example, in these circumstances?
Yeah, let me speak briefly just at least to the global picture that we're seeing. So I think one of the key messages that has come both from the High Commissioner's Office and also from my colleague, the Special Rapporteur Health, is the focus on non-discrimination in this context. And there is a really deep concern, and this I think also goes to the comment that was made in the chat around refugee and asylum seekers, that pre-existing and vulnerable groups will experience greater levels of vulnerability, but also unequal or uneven access to health. In the European context, I think there's this interesting question not only around derogation, but Article 2 requires proactive or positive implementation. So positive obligations exist under Article 2. And I think that raises a set of really interesting questions, both around derogation. Do you need derogation? Some countries have argued they don't need to derogate, not just, as Liam said, because there may be a constitutional barrier to that, but actually because the proactive or positive obligations under Article 2 actually undermine or cut out the requirement to derogate. That there's some new balance being constructed between Article 2 and Article 15 of the Convention, and I think that's an interesting thought experiment. We'll see what the court does with that. I also just think, and we note that in a number of countries, historically marginalized group, and I speak here of the United States in particular, where we're seeing deep differences between people, brown and black people's vulnerability to the virus in terms of pre-existing conditions, structural discrimination, access to health. All of those things also apply clearly in settings in Northern Ireland and in the Republic, where there are pre-existing structural inequities that will make some groups have less access, have particular health challenges. And I think the obligations there, both in terms of thinking through the proactive or positive obligations inherent in Article 2, as well as the non-discrimination requirements of Article 14, I think are going to be particularly important to think through.
If I might just add in terms of what we're seeing here, there was a separate piece of legislation introduced on the 27th of March, which largely had administrative measures about recognising people coming back to work in the healthcare system and so on. But it also had administrative changes to the Mental Health Act, which reduced the procedures around assessment for mental health, for involuntary detention and so on. And there is a particular risk there. We have no real data on what the use of those powers has been, but they do allow for people to be involuntarily detained without the normal access to justice. What we have been saying here, I suppose, about the Article 2 kind of issues is the need for statistical information about who is being affected by the virus particularly. And the Chief Medical Officer has been calling for that as well. We know that there's a problem with nursing homes, and we know there's a very acute problem. We also know anecdotally that certain groups, such as the Roma community, appear to be disproportionately affected. And we've called for, this is an essential step before the next review takes place, to provide better and clearer statistics about which groups are being affected in the present situation.
Okay, thank you both for that question, the answer to that question. Liam, just one quick question to you there from Paddy Kelly. Whether you have any information about liaison between the PSNI and the Guards, and in particular, has there been any sharing of personal information between the two police forces?
We have no information on that. There's been only very general references to coordination, but we've no details about that or about sharing of information. And certainly the Guards have been downplaying that. In the recent discussions about this issue about cross-border travel, there hasn't been any reference to accessing personal information on a cross-border basis for that level. And certainly, you know, this question about holidaymakers, for example, the Guards have certainly indicated that they don't see their role as going to holiday homes and asking people questions. They're focusing really on the transport level of it, rather than getting into questions about residency and so on. And I think that's an appreciation of the sensitivity and the difficulties that would arise in that context. So there may very well be information sharing, but we've not seen very much detail of that.
Okay, thanks for that. A question to both of you then, from Colm Kelly Ryan, in respect to non-derogable rights during times of public emergency, and really the question of what protections are available for people who are unable to receive protection from their own states. And in particular, what are your thoughts around how COVID-19 has frozen refugees and asylum seekers?
Yeah, maybe Liam, I'll start, and then so I think this is one of the sort of the refugee and migrant crisis in multiple parts of the world was one of the sort of, I suppose, sort of pressing issues before COVID-19, and COVID-19, of course, has created a further set of barriers to the resolution of that. I think we are seeing poor global coordination. The multilateral global system, as many on the call will know, is under significant threat. the Security Council was unable to meet for a period. There was a consistent view by one state that it shouldn't meet in COVID-19. It is now meeting, but not taking any action under Chapter 7, which would be where you might find some capacity to force a global response through the Security Council. But also, I think multilateral institutions have been struggling to manage what it will be required in order to manage these cross-border, multidimensional, complex issues. I think it's also just really obvious to say that the answer to COVID, which is in part around the presumptions that people have actually meaningful access to the exercise of socioeconomic rights. That includes the right of access to a home, that people have homes, that those homes are adequate, and that those homes are safe. It includes the presumption that people have access to water, right? So never has the question of the indivisibility of rights between even Colm's question of derogable and non-derogable, what is an essential right in a global pandemic? I think any arguments that the right to health is not a right, I think may well be moot in the context where we've closed the world down around the right to health. But it does speak to the enormous gaps, not just those sort of theoretical gaps, but the enormous gaps in the practicality of access. We are seeing, I think, at least from the UN's perspective, and I'll put up the link to the measures or the rights around migrants here, and we're just seeing huge practices of breach in the refoulement area. We're seeing a number of states returning individuals to countries where they are not safe. In particular, we're seeing mass practices in that regard from the United States at this point, which is deeply concerning. So practice is not good. And the challenge is, of course, to ensure, again, that those who are most vulnerable and have the least access to the basic capacities to actually manage the health challenges do so. And I'll turn over to Liam.
If I could just strike a positive note or an optimistic note on this, direct provision has been a pressure point here, and the housing for asylum seekers has clearly been shown to be a very high risk location. And interestingly, the Ombudsman this week came out and said that this crisis is demonstrating the general unsuitability of direct provision as a policy. And this is one of a number of areas where you could take an optimistic view that, in fact, the way in which this crisis has demonstrated particular failures of policy and how things are intolerable at the moment could create the political opportunity to say that if they were intolerable into the future. Direct provision is one, the homelessness crisis, and what has been introduced as effectively a ban on evictions in the current crisis also is another example. The urgency with which the COVID welfare payments were made available and the level at which they were pitched does raise all sorts of interesting questions about right to a basic standard of living and a basic level of income here. And also the sequestering of the private hospital system by the state to meet what was an anticipated demand. It now seems that that demand hasn't been needed, has created a debate or an appetite for, equality of access to healthcare and an acceleration of what was called Sláintecare, the government's medium-term strategy in that area. And we, talking to other civil society actors, are interested in this conversation about where do we go next and how can we create opportunities for dispensing with what is clearly a violation of rights and actually achieving urgency of rights. The public service card's another example. When it was an obstacle to rights in the short term, it was dispensed with. Well, why can't that happen in the longer term? It's a very optimistic view. And of course, there's plenty of reasons to be pessimistic that all of the negative things that Fionnuala's outlined might happen, but other realities are also possible.
Can I just add, Nora, I'm with Liam a little bit on the positive. I think I've said, just to end on a happy note, I do think that one of the things about crises, good and bad, is that they create opportunities. And so often they actually undo the assumptions of how things are done and how they can be done. And that, I think, lies a tremendous opportunity, both in terms of thinking about the indivisibility of rights and also the opportunities to rethink how we do the protection of fundamental rights post-COVID may actually be a really unique way to rethink some of the silos and the challenges that we've had before. So not all bad news, I think, necessarily.
Okay, I will take that opportunity to bring our proceedings this afternoon to a close on a positive note. First of all, I'd like to thank our speakers, Liam and Fionnuala, for giving up their time and sharing their expertise with us, and for being willing to take questions. I know I haven't got to everybody's questions, but I hope you do agree that it was a really interesting and thought-provoking afternoon, and I'm sure you share my appreciation for our speakers' contributions. If you're interested in joining us again, as I said earlier, you can sign up online for our seminar next week on rights and regulations in managing the dead in the wake of the coronavirus pandemic. We have Professor Heather Conway and Professor Anne-Marie Farrell joining us next week. And the week after that, we have an in-depth look at gender issues in relation to COVID-19. So thank you again for joining us this afternoon, and thank you for your patience and your contributions. I'm going to sign off now, but as I said earlier, if you want to replay this conversation or catch up on it at a later date, maybe share it with colleagues, it will go up online on the Human Rights Centre website. So speak to you all soon, and thanks again.
And if anybody is interested in the ongoing work of ICCL, I'll get killed for not saying this, at www.iccl.ie, and you can track the ongoing developments in the South over the next while.
Perfect. Thanks, everybody.
Thank you.